Good evening, ladies and gentlemen. My name is Leo Stoller. I'm talking to you this evening from the headquarters of AEAE. Americans for the Enforcement of Attorney Ethics. We're located here in Chicago, Illinois, right in the heart of America. In 1974, I started AEAE as an attorney watchdog organization advocating the strict enforcement of attorney ethics. The last 30 years, Americans for the Enforcement of Attorney Ethics has grown. We are now observing government officials for ethics violations. We saw what happened in New York with Senator, with the governor who recently resigned because of activities with women of the night. Every minute of every day, we have to police attorneys, government officials. Corruption is pandemic. And a free society creeps into every area of our lives. Fortunately, we have the First Amendment, the right to free press, the right to address our grievances. For me, the right to talk to you tonight about the strict enforcement of attorney ethics and governmental ethics. As part of our series on the enforcement of attorney ethics, we talk about litigation and the vehicles that help expedite litigation that you should be aware of. This evening we're talking about discovery in litigation. One party files a lawsuit known as the plaintiff. He sues a party known as the defendant. One defends, the other prosecutes. Football, the defense is called the defense. The prosecutor, one who prosecutes in football, is called the offense. In war, when one attacks, one is on the offense. When one defends, one is on the defense. Basketball, there's offense and defense. Soccer, there's offense and defense. When a plaintiff files a lawsuit in a state or federal court, first thing they want to do is serve discovery on their opponents. What is discovery? There is written discovery under Federal Rules of Civil Procedure, which permits a party to ask for document requests, permits a party in the position of either defendant or the plaintiff to ask for interrogatories. What are interrogatories? Those are a series of questions that one puts forward so that their opponent can answer those questions hopefully to narrow the issues of the controversy. And then we have what is once considered, and by many, admissions. And in the Federal Rules of Civil Procedure, it's called admissions is under Rule 36. And what is admissions? Admissions is a series of questions that are framed to ask a party whether they did or did not do something, and they have 30 days to admit these facts or deny these facts. For example, did you enter, if it's a contract dispute, did you enter into a contract? Admit or deny. Are you the president of Acme? Admit or deny. Did you breach the agreement? That's the question. You did breach the agreement. Admit or deny. And a party who fails to respond truthfully in admissions can be charged with perjury. We all know what happened to Clinton, President Clinton, when he was charged with perjury, lost his law license. A lot of individuals who engage in civil litigation, businessmen, not only lose their law license if they have one, but they can also lose their homes and their assets if they lie on admissions or in a deposition. What is a deposition? A deposition is where a party in litigation has an opportunity to ask questions to a witness. Witness can be represented by an attorney. These questions are asked under oath. That's called a deposition. In a recent case, which I have filed against the Village of Elmwood Park in Illinois for false arrest, false imprisonment, malicious prosecution, violation of my civil rights, I have put to some of the defendants a series of admissions. My former wife, who was responsible for signing a fraudulent police report against me, had me incarcerated for 3 days unlawfully. I submitted admissions to her, and those admissions were submitted beyond the 30 days in which they were supposed to be responded to. Consequently, in front of Judge Winkler yesterday, those admissions have been deemed admitted. Everything I asked is now admitted. Of course, the defendant was given an opportunity by the judge to submit some pleadings to explain why they were beyond the 30 days. And after that argument is made, if the judge does not allow those admissions to stand, then they will not stand. If he allows the admissions to stand, case is over for that defendant. They'll be adjudicated guilty. So it's extremely important when you're involved in litigation to submit your discovery at the earliest part of the proceeding. What does that mean? It means, first of all, you file a lawsuit against the party. Breach of contract, intentional infliction of emotional stress, trademark infringement, civil rights violations. If a company violates one's civil rights or an individual violates the civil rights of another party, they can file a lawsuit. After you file the suit, you serve discovery immediately, as quickly as you can thereafter. Lawsuits can be resolved very quickly, or much more quickly, if a party pursues written discovery at the earliest possible time. The next time we'll be discussing with you a motion to dismiss and a motion for summary judgment. Those are two vehicles to end the litigation, short-circuit it, before having to go to a trial.